Are you an aspiring notary looking to join millions of other notaries? Start your journey with the Notary Public Foundation by Derek Spruill. This essential guide provides the step-by-step process to becoming commissioned in your state. Don't stumble into the role. Walk into it with confidence. Grab your copy of the Notary Public Foundation by Derek Spruill on Amazon today.
Imagine this. It's 4:30 p.m. on a Friday.
Oh, the worst time.
Right. You're a paralegal, you are just completely exhausted, and your boss, who is a senior partner at your law firm, the guy who dictates whether you get a bonus this year,
Yeah.
he drops a document on your desk, and the client's signature is already on it. The client left the building like 3 hours ago.
Oh, boy.
And your boss just points at the paper and says, I need this filed electronically before 5. Just stamp it. I watched them sign it myself.
Right.
So what do? Do you protect your paycheck by keeping the partner happy? Or do you protect your notary commission by refusing a direct order?
I mean, that is the exact moment where theoretical compliance just crashes into harsh professional reality.
Yeah.
And if you make the wrong choice in that split second, you're not just risking your job. You are risking civil liability, criminal charges, and the permanent revocation of your state commission.
Welcome to Notary Knowledge. Eddie and Marylyn here. We are setting aside the basics today.
Yeah, no 101 stuff today.
Right. You already know the fundamentals of the seal and the signature. Our mission right now is a high-level briefing for experienced professionals. We're focusing squarely on severe liabilities, the systemic importance of the profession, and the rigorous compliance structures governing modern notarial acts.
It's really about understanding the immense power of that notary stamp.
Mm-hmm.
We're looking at how that tiny rubber seal shapes communities at a massive, macro level, all the way down to those terrifying micro-level conflicts that W-2 employees face literally every single day in corporate law firms.
Yeah.
The stakes are incredibly high. And as we'll see, the legal frameworks are just entirely unforgiving.
Absolutely. And before we get into the heavy statutory analysis, just a quick reminder to check out the Notary Knowledge books by Derek Spruill, which are available now.
Great resource.
They really are an essential resource for anyone serious about this profession, so definitely head over to the Notary Knowledge website to grab your copies. Also, just like we discussed in our recent session on identity syndicates,
Right, that was a wild one.
the threats to your commission are evolving rapidly. That's exactly why continuing education is not optional. It is your primary defense.
It truly is the front line of defense. And to start understanding the gravity of that defense, I think we have to pull back and look at the sheer scale of what notaries accomplish collectively.
Okay, yeah.
If we want to look at the macro impact of this profession, there is really no better example than the Notary Foundation of British Columbia.
Oh, interesting.
If you read their 2016 annual report, it's essentially a masterclass in systemic financial impact. I mean, since their inception, they have generated over $45 million.
Wait, $45 million?
Yeah.
Let me stop you there, because as someone looking at the economics of this, my first thought is, are they just price gouging the public? Like, where on earth does $45 million come from in a notary context?
Right, that's the brilliant part. It does not come from charging outrageous fees to the consumer at all. That massive sum is generated entirely through the interest earned on BC Notary's trust accounts.
Oh, I see.
Yeah, it operates on a mechanism really similar to IOLTA accounts for attorneys in the U.S.
Okay, right.
So when a notary in British Columbia holds client funds in trust, say, for a massive real estate closing, those funds generate interest.
Right.
So the foundation leverages preferred interest rates from financial institutions, pools that interest, and then they use it to fund critical legal aid, legal research, and public legal education across the entire province.
Okay, so they're acting as a structural financial pillar for the justice system. The notary is essentially the engine powering legal access.
Precisely. To put it in perspective, in 2016 alone, and remember, 2016 was a period of historically low interest rates.
Oh, yeah, rock bottom.
Yeah, even then, they provided a grant of $857,772 to the Legal Services Society of BC.
Wow. And what does that money actually do on the ground? Like, where does it go?
It directly pays for community workers who provide legal aid to vulnerable populations. It keeps the lights on at clinics that help people who are, facing eviction or navigating family law disputes without representation.
That is incredible. And from my reading of the report, they don't just dump money into massive, generalized organizations either. They target really specific, high-impact community projects, like um, take their support for POVNet.
Yes, POVNet is a fascinating case study in overcoming systemic barriers.
Right, because POVNet has been operating since 1997, essentially building a digital anti-poverty community. The foundation's grants really helped them tackle the digital divide head on.
Yeah.
And if you think back to 97, bridging the digital divide literally meant buying dial-up modems and showing legal advocates how to plug in a computer and access the internet so they could share case strategies.
It's wild to think about now.
Right. But today, thanks to that sustained funding, it means supporting platforms like Advocapedia, which is a secured wiki for advocates across the province to share poverty law resources and case precedents instantly.
They also fund highly complex legal reform, which is where the notary's impact really intersects with legislative history.
Okay.
The foundation provided a massive grant to the British Columbia Law Institute, or BCLI, for their Strata Property Law project.
I want to unpack this just a bit because the term strata might confuse some of our listeners here in the States.
Good point.
A strata property is essentially a condominium or townhouse complex, right? Where individuals own their unit, but they share ownership of the common areas like the roof and the foundation.
Exactly.
Yeah.
And the BCLI was tasked with reforming the Strata Property Act. They were specifically looking at a massive looming crisis, which was how a strata corporation is terminated when a building reaches the end of its life.
Because prior to this foundation-funded reform, terminating a strata required a unanimous vote, 100% agreement from every single owner. Which sounds fair in theory, but let's apply it to reality. You have a 50-year-old massive crumbling building in Vancouver. The roof is collapsing, the plumbing is completely shot, and developers are offering a fortune to buy the land and start over. But if one single owner out of 200 refuses to sell, the whole deal dies.
That was the exact gridlock. It created severe legal and financial paralysis. The buildings were literally decaying because they couldn't get a unanimous vote to terminate the strata and sell.
Jeez.
So the BCLI, which was completely funded by the Notary Foundation, did the deep, rigorous research required to recommend lowering that threshold.
And that research resulted directly in Bill 40, right?
Yes.
Which amended the act to lower the termination vote threshold to 80%, breaking the gridlock and bringing BC in line with most other Canadian jurisdictions.
Exactly. So when we talk about the power of the notary, we aren't just talking about a rubber stamp. We're talking about an institution that funds the research that literally changes property law and reshapes city skylines.
It is a phenomenal legacy. And reading through the history, that level of trust and political clout, it wasn't just handed to them. The Society of Notaries Public of BC celebrated its 90th year of incorporation in 2016.
Yeah.
They were incorporated back in 1926, and the early years were essentially a massive turf war.
A huge turf war with the legal establishment. You had historical figures like Eads Ward, who was their first full-time secretary, and Alexander Matthew in the 1950s, who fought fiercely in the legislature to solidify the profession's respectability.
Yeah.
They had to battle the Law Society, which was systematically challenging notarial applications, until they finally reached a critical gentleman's agreement to stop the automatic opposition. They carved out their jurisdiction through sheer grit.
It's just amazing how much structural power the profession wields at that macro level. But it's deeply ironic, right? Because while the profession as a whole has all this systemic power, on a micro level, the individual W-2 notary is often the most powerless person in the room.
Oh, absolutely.
Which brings us to our focus for In the Workplace Wednesday. We need to talk about the W-2 employee, specifically the law firm paralegal notary.
This is where the grand legal theory we just discussed crashes into the harsh reality of office politics.
Yeah.
We were talking about the dual identity framework. It's a structural paradox.
Yeah.
On one hand, a paralegal is fundamentally a subordinate W-2 employee. You take direction from the employing attorney, they sign your checks, they manage your schedule. But the second you pick up that notary stamp, you are a commissioned, independent public official bound by absolute state mandates.
And when those two roles collide, right, when the boss's demand contradicts the state notary statute, who wins? State law trumps employer directives every single time, right?
Yeah.
But the conflict of interest is baked right into the organizational chart.
Exactly. Let's analyze that Friday afternoon scenario you opened the show with. We'll call it the Patty scenario, based out of Iowa.
Yeah.
Patty is our paralegal. The boss drops the pre-signed document on her desk, demands she notarize it immediately for electronic filing, and just leaves. the client is gone.
It's the classic demand for an accommodation. The attorney is essentially saying, I know the client signed it. I vouch for them. Just stamp it.
Right.
And look, human nature says you want to help your boss out. You want to be a team player. But Patty knows that Iowa Code Chapter 9b explicitly states the individual executing the signature shall appear personally before the notarial officer. There is no attorney vouching exception in the statute.
None whatsoever. If Patty complies, she violates the physical presence mandate, which is the absolute bedrock of notarial law. But I want to explore the why here. It goes so much deeper than Patty just protecting her own commission.
Right, because if she stamps that document and the attorney files it with the court, she has just implicated her boss in a massive ethical violation.
Exactly. She implicates the attorney in a violation of the Iowa Rules of Professional Conduct, specifically Rule 3.3, which is candor toward the tribunal.
Oh, wow.
Filing an improperly notarized document, meaning a document where the jurat or acknowledgement falsely states the signer appeared before the notary, is making a forced statement of fact to the court.
So, by saying no to her boss, Patty isn't just saving her own skin, she's actually protecting the attorney's law license, even if the attorney is too arrogant or rushed to realize it.
That is the heavy burden of being an independent public official inside a private corporation. But let me ask you this. What happens when the pressure isn't a direct, explicit order from a partner, but rather a systemic, passive-aggressive corporate culture?
You mean when the system itself is designed to make compliance impossible?
Exactly. Look at the 2012 Nevada case involving a major mortgage servicing company. 4 W-2 notary employees face criminal charges for improperly notarizing tens of thousands of foreclosure documents.
Ah, the infamous robo-signing scandal.
Yes. And if you look at the mechanics of that scandal, the floor managers weren't necessarily walking up to these notaries and screaming, I order you to break the law.
Right.
Instead, they imposed daily quotas that were physically impossible to meet if the notary actually took the time to read the venue, administer the oath, and record the entry properly. The corporate expectation that assembly line velocity made proper notarization impossible. The employees were manipulated by their compensation and metric structures into acting as an automated assembly line rather than independent officials verifying facts.
And when the federal and state investigations hit, the executives pointed the finger right at the low-level W-2 employees. They just said, well, they're state officials. They should have known better. It is a terrifying position to be in.
Which brings up another massive vulnerability for W-2 employees: depositions.
Oh, yeah.
Ellen Lockwood, speaking extensively on Texas guidelines, highlights a profound inherent conflict. The question is, can a paralegal act as the impartial deposition officer, administering the oath for a deposition involving their own firm's client?
Okay, let me play devil's advocate here. From the firm's perspective, they're thinking, well, we already pay the paralegal's salary. It saves the client money if we don't have to hire an outside court reporter just to swear the witness in. Why can't they just administer the oath?
Because of the insurmountable inherent bias. You cannot be a neutral, independent public official administering an oath when your paycheck, your health insurance, and your livelihood come from one of the adversarial parties in the litigation. If a firm tries to cut corners like that, what is the immediate result?
The opposing counsel will spot it instantly. They will file a motion to suppress that entire transcript, arguing the oath was invalid due to bias, and they will likely win. You end up jeopardizing the entire case to save a few $100s.
Exactly. The W-2 paralegal must execute a conflict of interest refusal and demand the firm hire an independent third-party officer. The vulnerability of the employee notary is constant, which makes how they protect themselves so critical.
Speaking of protecting yourself when the firm won't, let's talk about record keeping. If you are looking to streamline your defensive record keeping and reduce administrative stress, you really need to look into the One Ledger Notary eJournal on the Apple App Store. It was crafted by the Magnificent Works team specifically for modern professionals who need robust compliance tracking.
Yeah, it's a game changer.
Listeners, use the code NOTARYNO50 to get 50% off the first-year annual plan. And while you are upgrading your workflow, make sure to check out our video podcast, No Notary, with Eddie Montes Travis. A phenomenal feature of that platform is the ability to report workplace coercion issues anonymously.
That is so important.
Also, do not miss Marylyn's 90 Seconds of Notary for rapid-fire compliance tips.
Having a bulletproof journal is not just administrative overhead. It is your survival mechanism.
Because let's look at the ultimate workplace conflict. The scenario is incredibly tense. A paralegal gives their 2 weeks' notice. During the exit interview, the managing partner slides a box across the desk and demands the paralegal hand over their physical notary journal, their electronic journal hard drive, and their stamp.
Happened all the time.
The partner argues, the firm paid for the stamp, we paid your commission fee, and that journal contains privileged attorney-client data regarding our cases. You cannot leave with it.
It is a classic intimidation tactic, and it highlights exactly why the journal is the ultimate shield. We often hear the journal called the black box flight recorder of a transaction. But honestly, I prefer to think of it as the transactional DNA.
Okay, I like that.
It is the notary's personal, official record of public office. It is the only objective evidence that exists if a transaction is challenged in civil court 3, 5, or 10 years later.
But wait, if I am playing the role of the firm administrator here, the logic makes sense to me. If the firm paid for the supplies, why don't they own the supplies?
Because the state did not commission the law firm. The state commissioned the individual human being.
Right.
The office belongs to the state. The commission belongs to the individual. And the employer is merely a bystander to the notarial act itself. However, this is where it gets incredibly tricky for traveling or multi-state professionals, because the rules on post-employment custody vary wildly depending on your jurisdiction.
Let's break down those state-by-state discrepancies, starting with Pennsylvania.
Pennsylvania is entirely rigid. It is a mandatory, universal journal state for all acts, traditional pen and ink or electronic, and custody is strictly independent.
So no wiggle room.
None. The notary must retain sole, independent custody of the journal and the stamp at all times. There are absolutely no exceptions for employers. If the partner demands the journal in Pennsylvania, you tell them to read the statute.
But contrast that rigid stance with Illinois. Illinois mandates a journal, but they provide a very specific and honestly somewhat controversial exemption for legal staff.
Yes, Illinois attempts to solve the attorney-client privilege issue. If the law firm retains copies of all notarized documents, the in-house notary is actually exempt from keeping a separate journal.
But think about the practical reality of that. You leave the firm, you don't have a journal because of the exemption. 5 years later, you get subpoenaed over a closing. You go back to the firm and say, hey, I need to see the copy of that document to refresh my memory. What if the firm shredded it during a routine file purge? You have zero defense.
It is a massive risk. And Massachusetts goes even further. They offer a broad statutory exemption for legal staff and paralegals for maintaining a journal entirely, though state officials heavily recommend doing it voluntarily.
Then you have Arizona, which has a fascinating, highly mechanical solution, the unique two-journal system.
Arizona actually recognizes the inherent conflict between public records laws and privileged legal data. So they instruct the notary to keep one public journal for standard entries and a second non-public journal specifically for entries that contain confidential state or federal data or violate attorney-client privilege.
So how does that work during an exit interview?
When you leave your job in Arizona, the public journal goes with you, but the non-public journal remains the property of the employer because it's deemed a protected legal file.
Okay.
It's an elegant compromise, but it requires the notary to flawlessly categorize every single transaction in real time.
And finally, Oregon. Oregon takes a totally different route. They make recording certain acts optional, but they explicitly allow a notary to enter into a written agreement with their employer, stating that the records and the collected notarial fees will stay with the employer upon termination.
Which brings up one of the most contentious compliance headaches in the industry, fee retention. Who gets to keep the statutory notarial fee? The employee who performed the act or the law firm that provided the desk?
The experts at Lien Law pose this exact hypothetical. A paralegal notarizes a stack of closing documents, a few affidavits, and a walk-in power of attorney. The clients leave a stack of cash on the desk for the notarial fees. Without a written employment policy dictating who gets that cash, it is a massive legal gray area. Unless you are in a state like Oregon that explicitly authorizes these fee agreements in statute, the default relies entirely on general contract and employment law, which is messy.
Which is exactly why a pristine, defensively structured ledger is vital. You have to document the financials with the same relentless precision as you document the identity verification.
Let's use an analogy to explain the mechanics of how this gets scrutinized during an audit. Lumping a negotiated travel fee and a statutory notary fee together on one line item is like going to a restaurant, and instead of the receipt showing $20 for the meal and $5 for the tip, the receipt just says food. $25.
Exactly. And when the state commissioning body, which acts like the IRS in this scenario, looks at that receipt,
Yeah.
they don't assume you took a tip. They assume you illegally overcharged for the regulated act itself.
They assume you charge $25 for a $10 stamp. It is a straight path to commission revocation. You have to itemize those fees on completely independent lines to prove your compliance.
That is how civil liabilities happen. The mechanics of the job require absolute precision, which transitions perfectly into understanding the mechanics of refusal and the extreme dangers of UPL, the unauthorized practice of law.
Let's talk about the blank document dilemma. A client walks into your office, slides a document across the desk, points to the bottom of the page, and asks, which certificate should I use? You're the expert. What do I need?
It is a massive trap.
Mm-hmm.
The instinct is to be helpful. But if you choose the notarial certificate for them, you have committed a crime. You are actively practicing law without a license.
Wait, just picking a piece of paper is practicing law?
Yes, because you are making a legal determination about the effect of the document. What you must do instead is explain the mechanical differences between the certificates and force the client to choose.
So you present the options. You explain that an acknowledgement is looking backward. It verifies free will regarding a past signature. The signer is confirming, yes, I signed this yesterday, and I did it willingly.
Correct. And a jurat, on the other hand, is an active present tense mechanism. It requires you to administer a verbal oath or affirmation under penalty of perjury, and the physical signing of the document must happen right there in your presence.
Right.
You explain those facts, and then the client must make the choice. If they cannot decide they have to consult an attorney, you cannot cross that line.
And you must be equally cautious when assessing a signer's capacity. We know you cannot refuse service based on a protected class. That is illegal discrimination and will get you sued instantly.
Instantly.
But you absolutely must refuse service if the signer lacks cognitive awareness.
Yes. If the signer is heavily medicated, disoriented, or visibly lacking the cognitive capacity to understand the transaction, you are obligated to halt the process.
But how do you document that? Because you aren't a doctor. You can't write a medical diagnosis in your journal, and you certainly shouldn't leave a vague subjective note like, didn't like how they looked.
Never write something subjective. You record specific objective behavioral details. You write, signer was slurring words, falling asleep mid-sentence, unable to answer basic questions about the document's purpose. Repeatedly asked what year it was.
Oh, I see.
That detailed objective entry is your sole legal defense when the family tries to sue you 3 years later, claiming you maliciously interfered with their estate planning by refusing to notarize a critical trust document.
The journal is your only witness. Which brings us to the human element of the job and everyone's favorite segment. Good question. What would you do? We have 5 highly specific scenarios submitted by our listeners dealing with these exact operational edge cases.
Let's analyze the statutory mechanics behind each response.
Okay, scenario 1 comes from Dominic in Nevada. Dominic writes, I was executing a high-value commercial real estate document. When I applied my rubber seal, the ink smudged severely due to the glossy paper, to the point where the expiration date of my commission was completely illegible. The client was in a massive rush, yelling about wire cutoff times, and said it was fine as is. What would you do?
Dominic, I know the pressure of a closing table can be intense, but you must reject that stamp immediately. An illegible expiration date makes the notarization fundamentally flawed.
Because if the date can't be read, the authority of the state can't be verified.
Exactly. If that document goes to court or gets audited by an eagle-eyed title company underwriter, a multi-million-dollar transaction can be thrown out simply because the date is unreadable. You must either restamp clearly on the document if there is room, or cross out the smudged seal, initial it, and attach a fully compliant separate certificate. Never, ever let a Russian client dictate your compliance.
The stamp is the state's authority. It must be visually flawless. Okay, scenario 2 is from Clara in Oregon. Clara says, a client came into my office for a standard acknowledgement. I asked them to leave a thumbprint in my journal as part of my personal best practices. The client adamantly refused, saying it was an invasion of privacy. Can I refuse to perform the notarization based on this?
Clara, the answer is no. You cannot refuse a notarization solely because a client declines to provide a thumbprint, unless you are commissioned in a state where the thumbprint is a strict legal mandate.
Right, because in California, for instance, a thumbprint is absolutely mandated for certain real estate deeds and power of attorney documents. If they refuse there, you must halt the act.
But Clara is in Oregon, and Oregon law does not mandate a thumbprint. Therefore, refusing service over a non-statutory personal best practice violates your fundamental duty as a public official to serve the public. You cannot elevate your personal office policies above state law. You note their refusal to leave a print in the journal, and you proceed with the notarization.
That makes perfect sense. Scenario 3 comes from Felix in Utah. Felix writes, I work as a wedding planner and I also hold my notary commission. One of my clients asked if I could officially perform their marriage ceremony to simplify the logistics. What would you do?
Felix, you must absolutely refuse the legal efficient role. This is a common point of confusion because a few states, like Florida or South Carolina, actually grant notaries the specific statutory authority to solemnize marriages.
But Utah does not.
Exactly. Utah notaries are absolutely not authorized to perform weddings as part of their official duties. You can help plan the wedding, you can arrange the catering, but you cannot be the legal officiant signing the marriage license in your capacity as a notary public. Doing so would invalidate the marriage and cost you your commission.
Wow, invalidating the marriage. That's a high price for convenience.
Yeah.
Okay, scenario 4 is a very tough workplace conflict from Eva in Colorado. Eva runs a shoe repair shop that also offers notary services on the side. She writes, a highly combative customer demanded I notarize a hand-typed document. It was full of severe misspellings and did not have a notarial certificate attached anywhere. I felt very uncomfortable, but my boss threatened to write me up or even fire me if I turned away a paying customer. What would you do?
Eva, this is the ultimate test of the dual identity framework we discussed earlier. You stand your ground. Colorado law specifically allows a notary to refuse service if they have a reasonable belief that the individual's signature is not knowingly and voluntarily made, or if there is a fundamental lack of comprehension regarding the document.
Furthermore, the missing certificate creates that exact UPL trap we just talked about. She can't pick the certificate for them.
Exactly. But most importantly, no employer, whether they manage a white shoe law firm or a local shoe repair shop, can dictate how a public official uses their state-issued stamp. Your boss's threat of a write-up is a blatant violation of your independent statutory authority. You pack up your stamp, you lock it in your drawer, and you refuse the act.
The ultimate authority rests with the commission, not the shift manager. Finally, scenario 5 from Gavin in New Hampshire. Gavin says, I was presented with a set of military orders. The documents clearly originated from Massachusetts, and the venue language pre-printed at the top of the form said State of Massachusetts. The client asked me to notarize their signature right here in my office in New Hampshire. What would you do?
Gavin, this trips up a lot of professionals, but you proceed with the notarization with one critical mechanical modification. The state of origin of a document does not prevent a New Hampshire notary from performing the act.
Because your jurisdiction isn't based on where the paper came from, it's based on where your feet are planted.
Exactly. As long as the physical signing, the identity verification, and the administration of the oath or acknowledgement happen physically in front of you within the borders of New Hampshire, you have complete jurisdiction. However, you cannot ignore that pre-printed venue. You must take your pen, cross out the pre-printed Massachusetts, write in New Hampshire, and initial the change. That venue block is your sworn statement of exactly where the notarial act took place.
It always comes back to the absolute truth of the moment. Where are you? Who is in front of you? And what exact act are you performing?
And that brings us to a final provocative thought to leave you with today. We talk constantly about compliance, regulations, and technology. The entire industry is currently pushing incredibly hard toward RON, remote online notarization.
And it makes sense on a surface level. It is incredibly efficient, it creates phenomenal digital audit trails, and it solves massive logistical hurdles for global commerce.
It does. But as that technology evolves and scales, we have to critically examine what a machine cannot do. A high-definition web camera and a knowledge-based authentication quiz can easily verify the security features of an ID card. But they are remarkably poor at reading the subtle human cues of coercion.
You mean seeing if someone is just out of frame threatening the signer?
Or just the psychological weight in the room. The physical human element, sitting across a desk, looking a signer in the eye and assessing their true, unforced intent and cognitive capacity, remains the ultimate firewall against fraud.
True weight of the public office. It is not just about the stamp, it is about the judgment. If you are dealing with these complex scenarios in your own practice, we want to hear from you. Email your questions to derek@dereksproul.com. We will try to answer as soon as possible at the end of our shows. Credits: exec producer Derek Sproul, lead writer Marylyn Lee Trotter, graphics Eddie Montes Travis, music Thomas Bynum, produced by Magnificent Works Business Solutions. Don't just be listeners of the knowledge, be doers of the knowledge. This is Notary Knowledge. Until next time.
Are you an aspiring notary looking to join millions of other notaries? Start your journey with the Notary Public Foundation by Derek Spruill. This essential guide provides the step-by-step process to becoming commissioned in your state. Don't stumble into the role. Walk into it with confidence. Grab your copy of the Notary Public Foundation by Derek Spruill on Amazon today.